Most of it, my Lord. We're before you today, my Lord, with respect to our application for sanitary orders. Our specific prayers are set out in our notice of motion dated 19th of February 2026. And my Lord, what is in contention is the cooperation agreement signed between the national government and Nairobi City County Government on 17th of February 2026. My Lord, we were having a conversation with co-councils out there with respect to Nairobi County and how it's been in the lead with respect to testing the limits of devolution. Reminded me, my Lord, of a similar experiment that took place in 2020. In 2020, Nairobi City County handed over functions to the national government. Among the issues that arose before this court in Okia Omtata versus the Nairobi Metropolitan Service and three others was the question of the non-involvement of the county assembly in the pre-approval of the transfer agreement. This court, when it found that indeed the failure to involve the county assembly violated the constitution, it then prompted the first respondent, to go and politically regularize these processes of the transfer. But my Lord, it was not without a cost. At the signing of this cooperation agreement on 17th of February 2026, the first respondent is on record saying that that arrangement cost Nairobi County 16 billion shillings in pending bills. And therefore, this time around, they're not trying to do a transfer, they're trying to do something else called a cooperation agreement. My Lord, while the Constitution is very clear on the question of transfers, and Article 187 has gone into detail to regulate how transfers of functions are to be undertaken, it is less clear when it comes to the question of cooperation agreements. Therefore, if we lost 16 billion shillings where the Constitution has a very clear process for transfer of functions, the unclarity with respect to cooperation agreement raises the question of how much we stand to lose as the residents of Nairobi County. In fact, my Lord, when the court was determining the case of Kio Mtata versus the Nairobi Metropolitan Service in 2020 with respect to the transfer, it touched on the question of cooperation agreements, and it said that even in the context of cooperation agreements, at paragraph 80 of the judgment, that even in the context of cooperation agreements, it must be done respecting the functional and institutional integrity, as well as the constitutional status and institutions of government at the other level. Among our submissions, my Lord, is that the current text of the cooperation agreement violates this important constitutional requirement under Article 189, 1A, as read with Article 6.2 and Article 1.4 of the Constitution. 189, 1A of the Constitution that requires functional respect of the functional and institutional integrity of the other level of government. Article 6.2 that provides for the distinctiveness of the two levels of government as much as it provides for cooperation. My Lord, it's not in doubt and it's not denied in any of the pleadings before you, including the submissions, that in the execution of the cooperation agreement before you, that the Senate, the County Assembly was not involved prior to the execution. In fact, my Lord, when you look at the submissions of the fourth interested party, the County Assembly, they admit that while the agreement was signed or executed on 17th of February, they became seized of the agreement on 20th of February and undertook public participation around 26th of February. Therefore, my Lord, the constitutional requirement under Article 185.4 for the pre-authorization role of the County Assembly, as well as Article 10.2a and 174c, that requires public participation was violated, because this execution of the agreement was done prior to the time when this matter was presented to the County Assembly. My Lord, with respect to the question of whether we meet the test for the grant of conservatory orders, the three-part test set by the Supreme Court in Veterano Vitamuya requires that we demonstrate three things. One, that we have an arguable case with the likelihood of success. Two, that we demonstrate that if the orders are not granted, the petition will be rendered nugatory. And four, that the grant of the conservatory orders are in the public interest. The question of non-involvement of the County Assembly prior to the execution of the agreement, the question of non-involvement of the public in terms of public participation prior to the execution of the agreement, are among the serious and weighty constitutional questions that we raise before this court, which you can find in paragraph 12 of our notice of motion and paragraph 17 of our submissions, where we've restated what are the 9 constitutional questions, my Lord, that we pressed before this court. This court's jurisprudence, my Lord, on the question of what constitutes an arguable case or a prima facie case with a probability of success is to the effect that all we need to demonstrate at this stage is that those 9 issues or those 9 constitutional questions that you can find in our paragraph 17 are actually arguable constitutional questions and they're not frivolous. Paragraph 17 of our submissions, that all we need to demonstrate is that they are arguable. And my Lord, reading the restatement under paragraph 17, as well as paragraph 47 to 83 of our petition. So paragraph 17 will demonstrate that they are arguable constitutional questions. But with respect to the likelihood of success, we refer the court to paragraph 47 to 83 of our petition, which then details the arguability of the issues and clearly demonstrate that they have a very high likelihood of success. My Lord, even then, the jurisprudence of the Supreme Court is to the effect that even if the court was to determine out of the 9 issues that only one of them was arguable, that should suffice in discharging the burden with respect to prima facie case with the likelihood of success. On the question of the nugatory aspect of the test, we do submit, my Lord, that if the conservatory orders we are seeking are not granted, my Lord, this agreement is already in operation. The agreement was to come into operation on 4th of March. It has been operationalized, and specifically, my Lord, even the County Assembly, the 4th interested party, was quick to try and ratify the unconstitutionality of its exclusion by ratifying that agreement a day prior to when it came into operation. On 9th of March, my Lord, the bodies established under the agreement met and began the process of implementing the agreement. But most worrying, my Lord, is that there are glaring constitutional questions in the agreement which were going to lead to the loss of public funds. And for the record, my lord, in Dari Limited and 5 others, the negatory test is purely a question of whether if we allow this agreement to proceed, whatever is going to be done under the agreement, will it be reversible? And our submission, my lord, is that the operationalization of the agreement will result in irreversible consequences. And if I'm to quote your brother, Justice Mamuye, in Okoiti and 2 others, versus Kenya Railway Corporation, that's petition E843 of 2025, that when it comes to public law remedies, the focus is on the preservation of the constitutional order and public resources. More specifically, my lord, at paragraph 104, your brother Justice Mamuye says that the dissipation of public funds is perhaps the most acute form of irreparable harm in constitutional litigation. And you can find that, my lord, in paragraphs 22 and 23 of our submissions. And our submission, my lord, with respect to the situation in Nairobi County is that, 1, the cooperation agreement does not clearly state who is implementing what functions. They do agree that we are going to cooperate on these areas, but they don't say who is going to do what. And when you move to the part on financing, they neither say who is going to finance what, from what resources. And therefore the challenge is that, 1, we're going to get a situation where both levels of government are implementing similar functions. Both levels of government are budgeting for similar functions. And therefore accountability becomes a problem, because then we don't know who are we accounting for what particular functions. But importantly, my lord, is that these functions involve the raising of revenue. The functions which you can find under clause 3.2 of the agreement include refuse collection. From refuse collection, we have fees for refuse collection. From the function of county roads under clause 3.2, we have parking fees. From the shared function of markets, we have licensing fees. The shared function of housing, we have rates and rents. The shared function of water and sanitation, we have water charges. All these functions that are supposed to be implemented concurrently have revenue that's supposed to be collected. The agreement doesn't tell you who is going to collect this revenue, how is this revenue going to be accounted for. And when you are spending money, what is the role of the county assembly, what is the role of the National Assembly insofar as appropriation of this money is concerned. Therefore, our fear, my lord, is that if the agreement opens a lacuna for the laws and misappropriation of public funds, not only the ones that are duplicated in terms of implementation, but also the money that is raised in terms of revenue from each of these particular functions. Because the agreement does not provide clarity on that particular issue. My lord, importantly also is the fact that the president did commit 80 billion shillings to the implementation of this agreement. The 80 billion shillings that are committed to the implementation of these agreements, and the rule, my lord, the constitutional rule is the national government's expenditure is by appropriation by the National Assembly. You can find this under Article 206 of the Constitution, as well as Article 220 to 223 of the Constitution. That the national government can only spend money after the National Assembly has appropriated and passed an appropriation act. But we are committing these 80 billion Kenya shillings. This is money that was neither approved in the last appropriation act. It is not approved or even included in the current budget policy statement. And we are apprehensive, my lord, that if we don't get the conservatory orders, the public interest in prudent and responsible use of resources under Article 201D will be irreversibly violated. The third test, my lord, is the question of public interest that requires this court to weigh whether the grant of public of these orders are in the public interest. The various court decisions, my lord, jurisprudence of this court, that public interest, especially, my lord, at this court's decision in Law Society of Kenya versus Attorney General and another, a 2020 decision, that the two matters that your brother Mwamuye says that this court ought to protect, that is the constitutional order and public resources, the public interest lies, the greatest public interest lies in upholding this constitution and constitutional order. And we submit, my lord, that the public interest lies in one, asserting the county assembly's pre-approval role under the constitution, asserting that public participation has to be prior and meaningful and not just performatory, asserting, my lord, that the imperative under Article 201D for prudent and responsible use of resources is imperative. We cannot have money being spent concurrently by two levels of government. And importantly, your brother Mwamuye in Okoiti indicates, my lord, that one of the considerations also is Kenya's current fiscal realities in determining public interest. We are currently undergoing a very tough economic situation where money is a problem. We can't even give subsidies for fuel. We have a serious public debt problem. Yet, my lord, we are foreseeing a situation where money is going to be concurrently spent by the two levels of government without accountability, without the involvement of county assemblies and the National Assembly. We are also seeing a situation where the National Executive intends to use about 80 billion shillings outside the budget and without the National Assembly's approval. Public interest cannot lie in supporting such a position, my lord, and this court ought to refuse any invitation. The public interest lies elsewhere. But importantly also, my lord, the grant of conservatory orders in this particular case will have no negative implication on the respondents whatsoever. Because until this cooperation agreement was signed, the county government of Nairobi was operating as a county with the executive and executive structures that are constitutionally given the mandate of implementing county functions. The County Executive Committee of Nairobi County is still functional. It's not been dismissed. The budgeting processes for Nairobi County's expenditure are still ongoing through the County Assembly. Therefore, my lord, there is no dysfunction whatsoever that's going to be injected into the functionality of Nairobi County if this agreement is, the operation of this agreement is stayed pending the hearing and determination of this petition. But importantly, my lord, any argument with respect to the national government supporting county government of Nairobi with respect to functions which are revenue intensive, Article 202 of the Constitution provides the mechanism of conditional grants. So if there is any project that the national government wants to implement by virtue of Nairobi County being a city or capital city, the mechanism of conditional grants under Article 202 allows it to be able to do that. Conditional grants are by nature that the national government gets to decide what project is to be implemented, how the project is going to be implemented, and how the county can account back to the national government for the implementation of that priority. Lastly, my lord, with respect to the question of public interest, your brother Mwamuye in Okoiti indicated that the balance of convenience must account for the fact that the orders sought are purely preservatory and temporary. My lord, we're not seeking permanent orders to stop the county completely from cooperating with the national government. All we are saying is that we temporarily halt the operationalization of the agreement, as both this court and as the Senate mentioned also look into the questions pertaining to the constitutionality of this agreement. Therefore, my lord, it is this court's obligation in exercise of its powers of judicial review to halt the implementation of this cooperation agreement, to allow it to be able to preserve the subject matter so that we're able to determine the constitutionality of the agreement prior to its implementation. My Lord, that's Katiba Institute submissions. You're most obliged.